Professor Ljubinka Kovačević will start with her first lecture related to labor law and gender equality, one of really most important fields, and the course so far is very relevant. So the first lecture is History of Labor Law from Gender Perspective, and the floor, Professor Ljubinka, is yours.
Okay, thank you very much, dear Professor Vujadinović, dear colleagues, good afternoon. I'm very pleased that you are attending the course Gender Perspectives of Labor Law, and I'm truly honored that I take part in this spring school Law and Gender. As dear Professor Vujadinović mentioned, our first lecture will be dedicated to the issue of development of labor law and gender perspective of development of labor law. Then we will try to examine crises and challenges of contemporary labor law and their influence on labor market. And our third issue that we are going to examine is actually intersectional discrimination of women with disabilities. Also, we will have one illustration of gender-based discrimination at the workplace, which will be connected with access to employment and gender-based discrimination of job seekers and job candidates. So that is our plan for today. I hope that we will have a good discussions and fruitful discussions, and to collaborate in appropriate way. So let's start. Briefly, I would just like to mention that labor law is actually a branch of law that regulates employment relationship. That is a relationship between employee and employer, and parties to employment relationship are not equal, since employee is a weaker party to employment relationship. He or she is a weaker party to employment relationship because employer has some prerogatives that are of importance for successful performance of activity of employer and good functioning of working environment. Namely, employers do have managerial prerogatives, they do have normative prerogatives, and they also have disciplinary prerogatives. And because of those prerogatives, in a legal sense, parties to employment relationship are not equal, but also there is economic level of that relationship, which is manifested in a fact that for majority of employees, work for employer and wages that deriving from employment relationship are actually the main or predominant source for living for majority of employees and members of their families, and that makes employee a weaker party to employment relationship also in economic sense. Since parties to employment relationship are not equal, the main aim of labor law is to actually protect employee as a weaker party to employment relationship, or to prevent abuse of employers' prerogatives. And very important tool for that is actually implementation of the principle of equality and non-discrimination. But at the same time, we have to have in mind that labor law also regulates collective employment relationships. Those are relationships between trade unions and employers or employers associations. So those professional organizations of employees and employers that are oriented towards protection, improvement, and representation of interests and rights of employees and employers are also parties to employment relationship, and they do enjoy different collective labor rights, like right to organize, right to collective bargaining, right to participation when it comes to employees, their right to information and consultation, and so on. So labor law regulates at the same time individual and collective employment relationships, and we will try to actually examine implementation of principle of gender equality in both individual and collective employment relationships. So let's start with the history of labor law. or development of labor law. It is actually established in second half of 19th century. Along with the process of industrialization, and main aim of labor law was actually to protect employees as a weaker party to employment relationship, as we already said, but also labor law has some other aims. Firstly, we have to mention the need to prevent unfair competition at the market, since actually protection of employees is connected with certain labor costs, costs for wages, for protection of health and safety at work, costs related to dismissal, and so on. And there is a need to prevent unfair competition. It is that there is a need to prevent employers to have a priority at the market by violating labor law legislation, social legislation, tax law legislation, and so on. Also, aim of labor law is to actually maintain social peace, or to contribute to social peace, because by regulating employment relationships, actually labor law tends to prevent individual and collective labor disputes. And finally, we can say that one of the main aims of labor law is actually social justice. That is just ideal, but by regulating employment relationships, we are trying actually to fulfill conditions for everyone to be in a position to obtain sources for his or her living, or for developing his or her personality through work for employer, or as self-employment, and so on. So those are the main aims of labor law, and we always have to have them in mind if we want to actually understand properly a gender perspective of labor law. As I've mentioned, labor law was developed. I have some problem. I cannot. I do apologize. I do apologize. Just for yes. Okay. Thank you. So when it comes to development of labor law, we have to have in mind that in those first phases of regulating employment relationships, the issue of equality of male and female workers was not on the agenda. Namely, unequal treatment of men and women in the world of work was based on gender division of labor. It was based on a hierarchy that existed in the family, in a society, and actually this period is marked by the failure to provide sufficient consideration of specific needs that female workers do have at the labor market. And on the other side, some special protection that was afforded to women, for example, because of protection of their maternity. Those protective measures eventually blocked women's opportunities to work under the same conditions as men, because there was so-called banning discrimination or legal blockade of access to well-paid jobs, but we will explain that later. So when it comes to that second half of 19th century and first half of 20th century, labor legislation or state intervention in the world of work was connected with the protection of the most vulnerable categories of workers, and those were children and women. When it comes to children, those interventions were connected with some abolitionist measures, meaning that minimum age for entering into employment relationship was introduced, and also we have some protective measures oriented towards improvement of working conditions of young workers. But when it comes to women, state intervention was connected with protection of maternity, and it was reflected in limiting working hours. It was also reflected in a ban on night work of women in industry. It was also consisted in some special measures concerning occupational health and safety of female workers. And in those first couple of decades, this protection was not even afforded to all female workers, but only to girls, to young female workers. For example, girls under the age of 21 in France and Luxembourg, or in certain countries, underground work, ban on underground work was introduced only to girls under the age of 14, for example, in Belgium, or in Denmark, because of the opposition from feminists, special protection of women included only a ban on work in mines. Until the last decade of the 19th century, there was no general special protection of female workers that was afforded to all female workers, regardless of their age. We have to have in mind that legislators actually were not asked to treat men and women equally, because equality of men and women was perceived as some kind of denying women authenticity and also obstacle to their liberation, because working for employer would mean for women to double their workload since they performed household work. So we are talking about the period in which there was an idea that is more important for women, for their personal development, to take care about children and to do household work than to work in a factory. But their work in a factory was important because wages of adult male workers were not sufficient for family, and there was a need even for children and women to integrate in labor market and to participate in labor market. But the main idea was not of the legislators to stimulate women to perform work in factories, but that was a necessity. And even in some legal systems there was a formal ban of on employment of married women. So in many countries it wasn't possible for married women to enter into employment relationship and to perform work for employer, subordinated paid work for employer. So we can say that in this context labor law was developed actually over the model of male worker who is employed on the basis of open-ended full-time employment contract. So labor legislation is conceived according to the model of male worker employed on the so-called standard employment contract, that is the contract which is concluded as open-ended contract for full-time work engagement, and that was further reflected in the field of social security in a way that protection against social risks like sickness, like accident at work, like old age, like invalidity, like unemployment, their protection against those risks was actually developed according to the model of a male breadwinner. So that is the model of a family where actually we have male breadwinner, women are caregivers, and in some way motherhood or marriage was actually a substitute for paid work for employer. And in next decades also labor law will be developed according to that model. Male worker without taking into consideration specific needs that female workers do have at the labor market, and at the level of social security there was a male breadwinner model. So that is some kind of starting point for developing labor law. So we can say that actually the power that men had in the family and the society actually facilitated their domination in the world of work, and vice versa. More specifically, that unpaid work of women as caregivers, informal caregivers at home, actually was reduced to the issue of family law, not of the issue of labor law. And unpaid work at home actually was in some way considered as the work that should be valued less than the paid work for employer. That led to legal invisibility of women when it comes to labor law, and also to some kind of legitimization of patriarchal concept of work and workers. When we come to the period of, that followed World War II, the end of World War II, that period was marked by intensive integration of women, inclusion of women in the labor market. Of course, that is true especially for Europe and North America. Many women started to work. This actually was a reflection of post-war welfare reforms that, among much else, improved the possibilities for women to attend schools, also to enter into employment relationship. And in that period, actually, economic autonomy of women was perceived as a very important part of their liberation and their autonomy, and main prerequisite of freedom of women. But when it comes to labor legislation unfortunately continued to regulate only a few marginalized so-called women's labor law issues, primarily maternity protection and special protection of women due to their weak constitution, which was reflected on ban on night work of women in industry, and then ban on employing women on physically demanding jobs, such as jobs that are performed underground, underwater, in construction, and so on. We had legislative intervention, which was, of course, improvement in comparison to the period of labor exploitation that existed before Second World War. But we have to have in mind that this period was actually connected just with special protection, which will, in some cases, actually have as a result banning discrimination of women, or preventing women to participate on equal foot with men in the labor market and to have access to well-paid jobs. I think that that could be perfectly explained and illustrated on the example of ban on night work of women in industry. In many European countries, in late decades of 19th century, there was a ban on night work of women in industries. And later, at the international level, that ban will be confirmed. Firstly, in convention adopted in Bern, and then in ILO, International Labour Organization Conventions number 441/89. We are talking about the period of the end of 19th century and first decades of 20th century. And I kindly ask you, if you like, to just say what do you think, what were the reasons for introducing ban on night work of women into industry? What were the reasons to actually introduce that kind of ban? Please, dear colleague.
Yeah, maybe protection of women from harassment, sexual harassment, violence, etc.
Yes, that was one of the reasons. Moral reasons were very important for introducing that ban, because there was a risk that women will be harassed or attacked when they're going to work or going back from work during the night, and that was one of the reasons. There were just one more moral reason, and it was considered that it is not appropriate for women to work or to be outside the home during the night, especially because that night work is connected with using alcohol, and it is especially inappropriate for indecent for women to work during during the night if they're working together with men. And so that was one group of reasons.
Also motherhood, not to leave children unattended during the night. I don't know what were the reasons, but
yes, protection. Yes, one other group of reasons was connected with so-called functional differences between male and female workers, meaning that women are dedicated to, of course, taking care of children and performing household work, and if they work during the night, then there won't be no time for them to rest, since they work over the day, and over the night if they perform work for employer, then there won't be a time for them to rest and to perform those family duties appropriately. Yes. Are there some other reasons for introducing ban on night work of women in the industry? What do you think? Can you mention some other reasons? Also, there were biological differences between men and women. In that time, it was believed that actually night work of women would have a negative effect on women's health, especially when it comes to the risk of tuberculosis or anemia. And also it was important to protect reproductive health of women. There are some other reasons that actually inspired legislators and later on International Labour Organization to introduce that general ban on night work of women in the industry. They were connected with economic reasons, because immense increase in night work will result in hyperproduction and consequently increased unemployment. That was also one of the reasons to actually introduce the general ban on night work of women in industry. And for decades, we had in labor legislation and International Labour Organization standards that ban on night work at women, but something happened in 1970s and later. Many countries decided to abrogate the ratifications of International Labour Organization conventions regulating night work of women. Administrative Council of International Labour Organization also abrogated conventions number 4 and 41. And when it comes to Convention 89, that also regulates night work of women in the industry, there was a protocol which was adopted in order to extend exceptions of ban on night work of women. And main reason for that was actually the jurisprudence of European Court of Justice. Why? Because France was the first state in which this change actually happened. European Community's member states that ratified International Labour Organization conventions on ban on night work of women in industry actually had a legislation that was not compatible with the European Community's directive on equal treatment of men and women. And for the first time, there was a case before this court against France. And European Court of Justice found that French legislation on ban on night work of women was not in line with European Community's directive on equal treatment of men and women in matters of employment and occupation. And the main reason for that was the fact that actually the results of scientific research in the field of medicine and also some other scientific fields showed that negative effects of night work are the same regardless of the sex of employee. Meaning that those negative effects, especially when it comes to the health of employees, are not connected with the sex of employees. So it is important for employers to prevent those risks regarding health of employees by organizing pre-employment or periodical medical examination of workers, or to oblige employers to transfer employees to another job if night work is detrimental for their health, or to, of course, introduce some other measures that could be of importance for health of employees, but not to introduce general ban on night work of women in industry, because in that way male workers were discriminated, and on the other hand we also had female workers in disadvantaged position, because they were prevented to perform jobs that are better paid, since night work is always connected with higher wages, and women were not allowed to perform those well-paid jobs because of that ban on night work of women. That's why in contemporary legislation, when it comes to European Union member states, there is no absolute or general ban on night work of women in industry. There is just a limitation of night work regarding female workers who are pregnant. During the pregnancy, it is acceptable to limit the possibility for night work of women, but when it comes to other phases of life of women, there is no reason, there is no objective reason that could justify the ban on night work of women, and that was actually the first case that stimulated those changes regarding special protection of women. Similarly, when it comes to ban on employment of women in jobs that are physically demanding, also we had a ban on their employment, but in 1980s, the process of so-called liberalization of those jobs started, allowing women to perform physically demanding jobs if they fulfill strict requirements that are actually fixed for those jobs. However, we still have in some countries like Azerbaijan, Cyprus, Moldova, Slovenia, Turkey, ban on women working in physical demanding jobs, which is constantly by Council of Europe and European Committee of Social Rights, which is a supervisory body that actually supervises the implementation of European Social Charter and revised European Social Charter. We have comments that this legislation with the ban on employment of women on physically demanding jobs is not in line with Council of Europe standards regarding equal treatment of men and women in matters of employment and occupation. So still there are some so-called statistical stereotypes, because of course majority of women will not be able to fulfill conditions regarding strength, height, weight, body mass index, and so on, which are important for successful performance of those physically demanding jobs, but that cannot be actually viewed as an objective reason to introduce absolute ban on employment of women on those physically demanding jobs, because it does not refer to inability of each and every woman to perform those kind of jobs. So that was something that was the first change. That will, in the future, actually be reflected in a slow abandon of that paternalistic approach of labor legislation towards women, and actually that opened up a space for the main rule, and that is to actually provide conditions for decent work for each and every employee, regardless of their sex. So that was a slow, yes.
And which are these physically demanding construction,
For
mining,
example,
or
yes, jobs in construction, in mining, jobs where employees are exposed to some, for example, biological or physical, or, for example, some cancerogen substances and so on, if that job includes vibrations or exposure to extreme temperatures, and if it is performed underwater, and so on. So those are physically demanding jobs, and all of those jobs are also well paid. We have to have that in mind. So that's why those two bans were paradigmatic when it comes to the change of the approach of labor legislation to actually regulating the position of female workers in this segment. So, although we were witnessing that gradual reorientation of labor legislation from paternalistic attitude towards that need to provide fair working conditions for all workers, labor legislation as a rule did not take into account experiences that are typical of female workers, and also did not take into account negative consequences that seemingly neutral labor law rules have on women. So that was the state of affairs during the last part of 20th century. However, in 1980s, social science is starting to apply a feminist method, and that was also important for labor law and labor legislation, because that opened up a new set of labor law issues. For example, the issue of the relationship between family and professional duties and the need to reconcile those duties, then to questions regarding sexual harassment at work, and other issues that were important, because a significant number of working married women and working mothers were integrated in the labor market. There was also increase in the number of educated female workers. However, some problems were still unresolved, and they're still unresolved. First of all, that is the problem of double working engagement of women. Double working engagement of women still represents a great challenge for labor law. Especially because the culture of capitalism actually underestimates the economic value of those jobs that are connected with raising children, caring for other family members that are dependent on the other people's care and help. Sometimes it overestimates the benefits of women's participation in the labor market. That can be illustrated by statistical data, because across the EU, for example, in 2016, the employment rate of female workers aged 20 to 64 was 65.3%, compared to 76.8% of employment when it comes to male workers. And in 2021, employment rates among male and female workers were also the same. Employment rates were 11% lower when it comes to female workers. In the same year, 2021, women represented 3/4 of workers employed on the basis of part-time employment contract. And moreover, 22% of those women that are engaged on the basis of part-time employment contract worked for less than 20 hours a week, which means that their wages were quite low, because we know that those workers that are performing work on the basis of part-time employment contract will have their wages reduced pro rata temporis, that is to say proportionately to the time spent on the work, and that will be of course later on reflected on their pensions and possibilities for advancing in a career, because those workers performing part-time work are usually marginalized. They don't have many opportunities for advancing in a career, and also they have problems to enjoy their collective rights, and so on. Then also, one tendency is that women nowadays work in lower paying sectors and at junior level jobs more than men, despite more women than men obtaining a university degree. That is something that we can qualify as gender segregation or occupational segregation of labor market, which means that the girls are usually stimulated to educate themselves for so-called typical female jobs, and boys to be integrated in so-called typically male jobs. And those typical female jobs are mostly jobs in the fields of education, with the exception of higher education, also in the field of healthcare, in the field of social care, because of the stereotype that women do have a natural ability to take care about others and to help them if they're ill, if they're young, and so on. And they're, of course, underrepresented in more, more promising sectors like information and technological communications, information communications technologies, than in the fields of natural sciences, and so on. And we can say that actually this is something that is quite challenging, especially if we have in mind that those typically female jobs are jobs that are accompanied by reduced pays or wages. I know that in the frame of other courses you discuss the issue of gender pay gap, but maybe just to say a few words about that. Why women do have wages that are lower than the wages of male workers? Maybe you have some views regarding that. How can we explain those differences in wages? You heard many arguments, I'm sure. Yes, of course, we can maybe have answers from our students that are online, or students that are present, please.
Well, due to that social pressure that women are primary caregivers, so it is either that they are factually absent more than men during the course of a year to attend children, sick leaves, parental. It's always expected that women will take that, even though in our legislation it's equated. Men can also take leave due to.
So one of the reasons is the fact that women, because of the need to perform family responsibilities, family duties, will have a longer breaks in a career, will mostly work part-time, which means that their wages will be lower. Yes, that can be one of the reasons.
Here I'm speaking of professions where the pays are equal, like public administration, etc. In this case, so because the main question here in the course was some people were kind of confused because, like we know, university professors all have pretty much the same wages. It depends on the faculty, of course, because the faculty itself has its own budget. How should I say?
In general, yes.
Yeah, in general.
Yes, but if we have in mind, it will depend on different possibilities for female and male professors.
To attend lectures, to be paid in lectures, everything. Those are,
so
everything.
So,
invited lecturer, who is invited, etc., etc. Sometimes, I know because I work in academia, it's expected that you offer for a lecture more money to a male professor than to female. Those are things that people do not anticipate, but people do think. They how should I say, they add value only based on gender to the equal, how should I say, equal professions, equal performers in the field, etc. So that's also one of the cases why. I mean, it's very complex, actually, the gender pay gap.
It's very, yes.
And especially when it comes to corporate law, like this privacy issue, disclosure.
Yes, actually, that is very important because there is no transparency of wages, and that issue is regulated recently at the EU level, transparency of wages, and it is some kind of part of our culture that it is not appropriate or even decent for job candidates to take part into bargaining regarding wages when entering into employment relationship, and that is especially not appropriate for women.
Exactly.
And then you have non-transparent procedures for fixing the wages. That can also be one of the reasons. And then we have as a secret, wages are a secret for other employees and so on. That can also contribute to
trend,
those differences. Are there any reasons, other reasons that can explain the gender pay gap? Maybe something that we didn't mention. Yes, colleague, please.
Well, I believe that it was all mentioned once again to stress out maybe on one hand the professional segregation and the fact that women are working in underpaid jobs, are more at risk of precarious work and generally, and on the other hand the fact that the guarantee of the same pay for the same work or the work of equal value is constantly being violated. So in terms of even the same work, the same job, women and men still do not earn the same.
Thank you. Yes, both of you are right, but there is one more reason, and that is the discrimination that is present regarding evaluating job requirements. Because job requirements are not evaluated equally when it comes to typically male jobs and typically female jobs. For example, we have physically demanding jobs that are connected with, for example, pulling some loads. And in typically male jobs, that will be taken into account and reflected in the wages of male workers. But when it comes to female workers, that won't be important. For example, loads are just objects, not, for example, patients in healthcare centers, not, for example, beneficiaries in social care institutions, and so on. So in those typically female jobs, you will not have that requirement of a job as a requirement that is important for the wages. Also, just dynamic strength of muscles is important for physically demanding jobs, not, for example, long-standing. Jobs that include long-standing, as is the case with many typically female jobs, are not regarded as physically demanding jobs, and so on. So this is also one of the reasons we don't have equal treatment of job requirements, especially when it comes to physically demanding aspects of those jobs. So that can also explain maybe a gender pay gap. Also, we will have, for example, higher wages for managerial jobs where males are overrepresented, male workers mostly are overrepresented, but we will not consider as a job with the special responsibility jobs in education or in kindergarten and so on. So there is also a difference regarding evaluation of job requirements. Of course, this is a complex issue, and I know that in the course which was conducted by Professor Nikola Ilic, you discussed the issue of gender pay gap, but just to mention that is also one of those unresolved problems that we still are looking how to find the solutions, appropriate solutions, having in mind, of course, legitimate interests of employers, but moreover, legitimate interests of employees. Of course, the role of laws, the role of statutes as instruments for achieving social change that is connected with gender equality is quite limited. And that's why it is important to mention some important labor law instruments that are from the field of collective labor law. And that is social dialogue, which can have as its parties trade unions, employers associations, but also we can have a state as a party to social dialogue as well, not just state as employer, because, for example, employer of public servants, but also state as a party to social dialogue in order to try to regulate issues that are of importance for all three parties, for trade unions, for employers, and also for the state. And collective bargaining is very powerful instrument for improvement of position of workers, among much else regarding those gender issues. The result of collective bargaining are collective agreements. Those are special sources of law that regulates working conditions and rights deriving from individual employment relationship, but also relations between trade unions and employers or employers associations. Unfortunately, we can say that gender issues are rarely regulated by collective agreements. That is the case not just in, for example, Central European countries or Balkan, but also Western European countries. And this can be explained by many reasons. I have in mind some of them, but what do you think? How can we explain that modest regulation of gender issues in collective agreements? What can be the reason for that? Why we don't have rules concerning collective agreements, don't have, I do apologize, rules concerning gender equality in collective agreements, although both employers and employees are interested in those issues? How can we explain that fact that there are no rules concerning, for example, prevention and protection against gender-based discrimination of job seekers or employees? Why we don't have, for example, rules concerning interviews with job candidates in order to prevent those impermissible questions regarding family planning or some other issues? Or why we don't have rules concerning, for example, equal opportunities regarding advancing in a career and so on? How can we explain that? What do you think that are possible reasons for that actually problem that we have, and that we do not use powerful instrument as a collective agreement is to try to solve that problem?
I can mention some just to provoke the discussion. First, in the trade unions, majority are male members. By rule, I would say maybe this is a biased constatation, but by rule, I think they have patriarchal mindsets. They do not pay at all attention or are not aware of an importance of this different dimensions of gender issues. On the third side, complementary, even if female workers are the members of the syndicates. By rule, again, they are not enough. Their voice is not enough heard, and they have not been used to loudly speaking about their issues. Just as a digression, I was the member of the coaching project in Serbian police, Swedish police, Sweden, and collaboration with Swedish police was included. And there was an idea, besides other things, besides the aim to raise awareness of all structures in the police, starting from the leading parts, etc., also to organize female police, police women networks, to empower themselves from inside in order to overcome, to make bigger pressure, to be themselves more aware of the issue and ready to put on agenda their issues.
Thank you, dear Professor, for this intervention. Do you agree with our dear Professor Vujadinović, or you can see some other reasons? Well, as Professor mentioned, yes, this can be explained, among much else, by underrepresentation of female members in trade unions. When it comes to European Union member states, approximately 40% of female workers are unionized. So we have 60% of female workers that are not members to trade unions. But it is also important to have in mind that those trade union female members are not represented in a proper way in trade unions bodies that are actually included in collective bargaining or are making important decisions. That is the fact. For example, just 5 to 20% of seats in those trade union bodies are actually seats for female workers. 5 to 20%, just 5 to 20%. Yes, we have, as you mentioned on the example of police and that training that you were included, there in most of the trade unions we have so-called female sections of trade unions, young members section and so on, but that is not sufficient. Because female workers are not actually integrated in collective bargaining boards, in other bodies that make important decisions. And when it comes, for example, in status bodies, quite modest number of we have quite modest number of female workers. The exception are actually working groups whose members are elected on the basis of expertise. Their representation of women is somewhat higher. So that is one of the reasons. Colleague wanted to add something, please.
Yeah, I wanted to, I mean, the main question is who are the negotiating parties, always? What gender? So that's actually, my logic was pretty much the same. So leaking pipe phenomenon one aside, I mean, gender unions are specific, these trade unions, etc. But it's what we know from, general knowledge, it's that what you said, I even thought that numbers, percentages even higher in the, how should I say this, decisive bodies, but it's very low. Decision making, I mean, it is where it all begins, so.
Yes, of course, we don't have reliable data that higher number of women in trade unions or those decision making bodies will necessarily lead to better representation of gender issues in collective agreements or improvement of this issue, but this is really, I also do think, important reason for this imbalance that we have. But we have to have in mind that women are also underrepresented in employers' associations, and that is very important. If you don't have women representatives in employers' association, then you will not have adequate reaction regarding, for example, self-employment of women, improvement of working conditions of women, adopting, for example, special codes of conduct that are of importance for gender equality, diversity plans, diversity at workplace plans, gender action plans, and so on. That's why it is important to have female workers represented not just in trade unions but also in employers' association bodies. And moreover, it is very important to have a balanced representation of genders, different genders, in tripartite bodies like socio-economic council or other tripartite bodies that consists of representatives of trade unions, of employers' associations, of state, where actually issues that are of importance for three sides are examined, and there are different activities oriented towards compromise of issues that are not just strictly related to employment relationship, but also to environmental protection, also to demographic issues, and all other issues that are not directly connected with world of work, but are important for world of work. That's why we need women actually in not just trade unions, but also in employers' associations and tripartite bodies. Maybe that is the one possible way to improve the position of female workers and to actually introduce those gender issues in collective bargaining agenda. Do you have in mind some other mechanisms that may foster gender diversity in membership and the governing bodies of trade unions, employers' associations, tripartite bodies like Socio-Economic Council? What do you think that can be helpful to foster gender diversity in membership of trade unions, employers' association? How can we change this state of affairs?
Maybe some additional, how should I say, wages or some like incentives, economic incentives. Because if you are a member of these leading bodies in trade unions or wherever, it always presupposes that you will be more active and you will attend more hours after your work to that bodies and be part of that. So there will be, that is also this intricacy with this position that sometimes women don't want to accept these positions due to family and care obligations. So this is like and we have to take that into consideration and give them like incentive to join, to have some reimbursement. Whatever that will be, reimbursement in 3 hours, or whatever, maybe it...
Yes, you're right, but when it comes to those incentives, they do exist regardless of the sex or gender of trade union members or employers associations members. They do have some rights and benefits regarding their participation in collective bargaining process or other activities that are of trainings and other activities that are of importance for their inclusion. But so there, in that sphere, we don't need for additional intervention. But when it comes to the second reason that you mentioned, I do believe, and I agree with you, that maybe better instruments for reconciling family and professional duties would be helpful for women to actually participate more in those trade unions activities, and then to have maybe even quotas for female workers. Some countries experimented with that to stimulate women participation in trade unions. They introduced actually quotas for female workers, or also workers with disabilities, young workers, and so on, in order to have all of those groups represented in trade unions, in order to have better regulations of individual and collective employment relationship.
Something in chat.
Yes, in chat. I do apologize. Thank you very much. Thank you very much, Professor, that you mentioned. Just a second. One of our colleagues, unfortunately I cannot see the name, said pay gaps can be hidden behind salary ranges for the same position. Well, we passed that time, but yes, dear colleague, you are right. I do agree with you. Well, quite complex issue and very provocative without some final true answer, because there is still many space for improvements. As I can see, this was the only intervention of our colleagues that are also attending our course online. So we mentioned legislation adopted by public authorities. We mentioned other sources of law adopted by public authorities. We mentioned sources of autonomous labor law, like collective agreements. We can also have some other agreements concluded between representatives of employees and employers. There is a great potential of gender equality action plans, as also autonomous, non-binding, legally non-binding, but influential strategies and other similar documents that can improve the position of female workers. But let's see, is there a chance to have important contribution of international standards to gender equality in the field of labor law? Of course, it is not easy to assess the importance of international both universal and European standards for protection against gender-based discrimination. It is not easy because often we have that discrepancy between rhetoric of international discourse and situation on the ground. But what can we have as reliable data? We can look at the number of ratifications of certain international conventions regulating the issue of gender equality, and say that number of ratification is high, that actually that reflects wide, at least if only formal, acceptance of principle of gender equality. For example, United Nations Convention on the Elimination of all forms of discrimination against women, or International Covenant on Economic and Social Rights, or International Labour Organization Convention number 111 on discrimination in the world of occupation and employment. Those conventions do have a quite high number of ratifications, so we can say that formally gender equality at work is accepted widely as a principle of labor law. However, number of ratification is not sufficient to have effective implementation of gender equality principle, because although those conventions are flexible enough to be ratified by dramatically different states regarding their legal tradition, regarding their economic structure, demography, and so on, still there are many challenges regarding implementation of those conventions, and supervisory mechanisms are not accompanied by a possibility to impose legal sanctions. Sanctions are just political. That is also one of the reasons when it comes for example, International Labour Organization conventions. When it comes to Council of Europe, we can say that European Committee of Social Rights, which is a supervisory body for European Social Charter and revised European Social Charter, is very important, especially when it comes to those positive action measures, affirmative action measures, and their understanding. But we should also mention one very important instrument, and that is when it comes to International Labour Organization, actually a set of conventions, along with that convention number 111, which is specifically dedicated to regulating discrimination in matters of employment and occupation. We do have convention number 100, which regulates equal pay for work of same value. Then we have a special convention dedicated to workers with family responsibilities, which is very important, and it regulates not just the position of workers with young children, but also workers who have family responsibilities towards persons with disabilities, or older family members, or other family members that are dependent on other people's care and help. Then we have, for example, other conventions, especially conventions that regulate those non-standard forms of employment, like part-time work. Then conventions regarding protection against unfair dismissal, because one of those reasons that cannot be considered as valid reasons for termination of employment at the initiative of employer are connected with sex, gender, family duties, and so on. So we have a quite number of conventions at the International Labour Organization level. At the level of Council of Europe, I mentioned European Social Charter and revised European Social Charter, which actually guarantees in Article 20 right to equal treatment in matters of occupation and employment on the basis of sex. And we have, of course, very developed secondary legislation of European Communities or European Union. Those directives in matters of occupation and employment are very important in comparison to international standards, much more detailed, and of course that mechanism of protection of those rights before European Court of Justice or Court of Justice of the European Union is very developed and very important, because it influences a lot on interpretation of those standards regarding discrimination at work, and especially discrimination which is gender-based. Or firstly, it was sex-based, but now we can say that it is also connected with not just the principle of equality of men and women, but on the principle of gender equality. So that is something that I also wanted to mention when it comes to international standards and their contribution to the implementation of gender equality principle in the world of work. And now we have one new issue to examine, and those are challenges and crises in contemporary world of work and their gender perspective. We will talk about many challenges that are actually present nowadays when it comes to labor market employment relationship, both individual, collective. We will mention, of course, that economic and political turn towards neoliberalism, because it influenced a lot on regulating employment relationship. We will mention economic and financial crisis, since labor law and social security law are very sensitive to economic and social crisis, and that is also important from gender perspective as well. Then we will mention technological change, demographic change, climate change, all those actually challenges to contemporary societies, but also to contemporary labor law. I will mention briefly just the most important of them. Let's start with that economic and political turn towards neoliberalism. Of course, our dear Professor Vujadinović is the best expert we have in this field, but this will be my labor law view on this issue. That turn towards neoliberalism influenced a lot on labor legislation, because the main idea was to stimulate flexibilization and deregulation of labor law, and to reduce state costs for protection against social risks. There was an idea that those obligations that employers do have when implementing labor law, social security law, tax law, are actually accompanied by high direct costs but also indirect costs. And because of those high costs, employers are not stimulated to actually employ employees on the basis of standard employment contract, and they're moreover stimulated to engage them in non-standard employment contracts, in new forms of work, or even for undeclared work. That's why the idea was to actually make labor law more flexible, to introduce many non-standard or flexible employment contracts that will allow employers to adapt themselves better to the changes at the market, and at the same time to protect employees whose, of course, position will be less stable than it was when they're engaged on the basis of open-ended full-time employment contract, by improving their employability, meaning that measures should be taken to improve the ability of workers to adapt to the jobs that are available at the market. And that was viewed as some kind of substitute for job security. So employability was considered as a substitute for job security, and the whole idea was developed at the level of the European Union in the frame of the concept of flexicurity. Strange word, combo of flexibility and security, that is the flexicurity, meaning that you have to stimulate flexible working engagements, flexible working conditions, and at the same time to provide some measures for employees to have security regarding the period of unemployment, for example, to have a decent or even generous prestations, benefits, unemployment benefits during that period, but also to have skills to find quickly a new job after termination of employment. And that was one very important concept that was accepted by many states. However, the results of the implementation of that flexicurity concept are not good. With the exception of few states, in majority of European Union member states, the implementation of flexicurity concept didn't lead to improvement of employment, nor did it lead to improvement of employability. We can say that flexible labor market actually almost exclusively benefits the employers. And that high standards of protection of workers actually won't affect the general rate of employment or unemployment, but will affect the categories of workers that will lose their jobs, and rigidity of labor law protection actually leads to an increase in unemployment of women, as well as young workers, low-skilled workers, and so on. So we can say that the decrease in labor law protection that was actually provoked by neoliberal tendencies led to marginalization and poverty of many vulnerable categories of workers, and it also led to marginalization and poverty of many female workers. Position of female workers was worsened also by neoliberal cuts in welfare state, which make actually women more responsible for caring, And at the same time, since we have worsening of working conditions as a consequence of this tendency, female workers as well as male workers needs to work very long hours or to have 2 or more jobs, and in combination with long working hours or performing 2 or even more jobs, it is very demanding to combine that with family responsibilities, and you have actually those cuts in social welfare, and that is especially demanding for women since they perform in most of the cases those household works. That was a first tendency. The second one is connected with demographic change. Of course, very complex issue, but just to mention the most important tendencies that are connected with population aging, tendency that is connected with increase of life expectancy. Of course, that is a great success of our civilization, that we live longer. However, that is connected with many challenges. So if we live longer, then the risk of certain cerebrovascular diseases is higher, Alzheimer, dementia, and so on, is higher. It is there is a greater risk of those health problems that are connected with dependence on other people's care and help, and that's why there is a need for workers to actually be informal caregivers, because of course there is a need for rising institutional support for elderly, but also there is a need for actually both men and women to be informal caregivers for elderly, because capacities of social care institutions, health care institutions, hospices and others are not sufficient or are not of good quality. The same is true for kindergartens and other child care institutions. We have also to have in mind the fact that many older women care for family members, grandchildren, parents, and in that way older women actually help younger workers to reconcile their family and professional duties better. And because of that, grandmothers or other older women that are members to a family will perform work on the basis of part-time employment contract, and that will influence their professional career, later on possibility to obtain pensions and so on. Of course, that there is a need to maintain working ability and motivation of older workers, which is reflected in the concept of active aging. But on the other hand, we have the concept of intergenerational solidarity, because we need to keep in the labor market older workers as well as young workers, and to actually find a way to integrate both categories of workers in the labor market, and that is very, very demanding. When it comes to young women, they're at higher risks of unemployment than young men. There are many cultures where they're encouraged to marry early and to become mothers. They're also stimulated to, in line with occupational segregation, perform low-paying occupations and jobs with little possibilities for advancing in a career, and so on. So those demographic changes also have their gender perspective. This is also important to have in mind. Of course, one very important demographic change is connected with intensive international migration. I know that you had a course which actually dealt with this issue in details, but now if we have in mind those economic migrations, that is very important tendency that also has a gender perspective, which you have to have in mind. Of course, that intensive international migration process can have a positive impact on host countries, especially if those are countries with low birth rates. But on the other hand, there is a risk that migration would deepen economic problems that do exist in host countries if they have high unemployment rates of domestic workers. Also, this can have as a consequence establishment of various status for migrant workers, and some of those status are extremely vulnerable. It is especially important for female migrant workers, since majority of female migrant workers are employed in so-called 3D jobs. 3D jobs, those are dirty, dangerous, and demeaning jobs. This is especially true for first generation of migrant workers, while migrants of second and next generations are in better position since they actually were educated in the host country, and possibility for them to find a job and maintain the job and to advance in a career are much better than in comparison to those first generation female migrant workers. Then female migrant workers are usually facing intersectional discrimination. Also, the special risk is connected with their work, which we can call paid household work. They work as a domestic servants, which is not appropriate and correct term, but that is also connected with the risk not just of intersectional discrimination, but also forced labor and many other very delicate issues. Finally, there are many problems even with women who come to foreign country for family reunification, because until recently many countries were denying those women access to labor market during the first couple of years of their stay. So we also have to have that in mind as well. Then we have a tendency which is connected with economic and financial crisis. This is also a very important issue. Of course, we all have in mind COVID-19 pandemic crisis, but also we still remember the effects of 2008 crisis and austerity measures, because they were very important for the position of female workers in our country as well as all others. I do apologize for our country, but I know that we have participants from all over the world. And the consequences of both crises have hit women particularly hard, and they actually deepened the existing gender pay gap and existing inequalities between female and male workers regarding working conditions. Of course, labor law, social security law, they are very sensitive when it comes to economic and financial crisis. Interestingly, economic and financial crisis in their first phases usually affects the most male-dominated sectors. So male workers will be actually those that will have negative impact of crisis. But in later phases, also women will be particularly in a disadvantageous position in comparison to male. For example, 2008 crisis and austerity measures gave rise to unwanted part-time work. And that is actually reflected in the fact that 3/4 of workers performing their work on the basis of part-time employment contract are female workers. Also, that gave rise to precarization of work, other forms of precarization of work. Many new forms of work were introduced in the labor market. And of course, they're marked with many problems for workers. including, among much else, the problem whether or not those workers are employees or are self-employed. For most of them, there is no a way to actually obtain labor law protection, since they're qualified as self-employed, although in reality there are essential elements of employment relationship in there with the employer. Of course, many of them are performing undeclared work, and so on. When it comes to negative consequences of that pandemic crisis, of course that negative economic consequences have hit sectors in which female workers are overrepresented, as was the case with healthcare, with service, and so on. Since many jobs have been reduced in those sectors, or on contrary, we had a greater need for workers, and then there was a difficulty to balance family and professional duties because of more intense telework on one hand, and on the other hand there was a suspension of kindergartens, schools, restriction on movement of the elderly due to lockdown, etc., and that was quite challenging for female workers to actually reconcile their professional and family duties. So that is also one tendency. Then we have to have in mind that crisis-induced unemployment is always connected with worsening of working conditions. Working conditions are worsened not just regarding female workers but also by male workers. Of course, because their employer will have much more impact on working conditions that it is allowed by legislation, since you have a reserve army of workers waiting for any job to be accepted and to be performed. And this means that actually all workers, both male and female, are facing many problems, because we can say that the main characteristic of, main feature of contemporary labor markets is job quality erosion. That is something which is important not just for female workers but also for male workers, and paradoxically that means that male workers will have lower wages, and that reducement of wages of male workers will actually reduce the gender pay gap, which is some kind of paradox. Of course, we don't want to have that kind of instrument for reducing gender pay gap, but that actually happened in some European Union member states, that because of worsening of working conditions, you have has some kind of secondary negative effect, actually a reducement of wages, which affected the reducement of gender pay gap.
Just to,
yes,
but it also, but I suppose that it also reduced the how to say, the common income of the family.
Of course,
But before that, if Professor Ljubinka, if you allow me, are there any comparative analysis, or can you now consider this? I don't know how exactly to articulate the question, but interrelation of female workers in precarious fields of work compared with migrant female workers in gray economy, home help, etc. So how is there competition between? Is there similarity in positions? What is the situation if you compare? I think it would be interesting to at
very
least
important,
in
very important.
So in
issue.
the context of the COVID crisis, economic crisis, everything, environmental. So in this contemporary context, so interrelation of those low-paid women in these precarious conditions, generally speaking, faced with and compared with, or maybe coming into conflicts, into competition or whatever with migrant female workers and migrant male workers maybe.
Yes. When it comes to migrant workers, they are not uniform category. We have many different statuses. Low-skilled workers, whether they're male or female, are facing many problems regarding a possibility
migrant female workers in services and
migrant female workers are even those women that are well educated are also engaged in those household work and other jobs that are connected with the care of children or dependent older or dependent adults, and they are facing many risks. For example, risk of intersectional discrimination, because those household work are usually performed by certain groups of certain race, ethnicity, and so on. This is some kind of tradition in many countries. Then migrant workers are usually employed as seasonal workers in agriculture, for example, which is also very another seasonal jobs, which is also very delicate issue, because there is in many countries possibility for seasonal workers to be engaged in a simplified way without entering into employment relationship, because there will be a need for their work for a few months, even few weeks, but maybe they can work longer, and they do not have almost any protection, since they do not enjoy labor law protection. They do not enjoy social security law protection. Most of them perform undeclared work. For majority of seasonal workers, if they are engaged on the basis of that simplified engagement, which do not presuppose entering into employment relationship, there are actually there are many risks. For example, if they are engaged on the basis of vouchers, which we have in some countries and so on, it is not easy to make a comparative overview, because there are many differences, but those seasonal workers are actually left without any protection. On them, you don't apply rules concerning, for example, work permit, as is the case with other migrants, which actually means that without any control, you can engage a seasonal female worker to perform some seasonal jobs, or even to perform some jobs that are not seasonal, but you actually have some kind of bogus seasonal job, and to actually open the door for labor exploitation, to open the door for other abuse, other forms of abuse of employers' prerogatives, because employers do know that those seasonal workers will not actually initiate proceedings for judicial protection, or will not contact the labor inspectorate, or will not initiate some other procedure for protection of their labor rights, because they're dependent on employer. That is the very, very risky situation. And when it comes to, of course, irregular migrants, their position is even worse, since, of course, they're in risk of deportation, they're in risk of sanctioning, because they are not legally residing or entering into a host country, or working without work permit. So it is quite complex issue. And of course there are asylum seekers, refugees, which are in the most vulnerable position, and unfortunately in many countries those rules concerning asylum seekers are not compatible with their true needs concerning integration in the labor market, because you have to wait for a long period to be in a possibility to integrate into labor market, and there is no true integration of refugees without their integration in a labor market, because of course effective enjoyment of labor rights is a prerequisite for effective enjoyment of all other human rights and freedoms, and it is a prerequisite for, of course, full participation in the life of a society, social life, political life, economic life. I don't know whether I explained a little bit just what you mentioned. Then let's mention just a few more tendencies that are of importance for employment relationships, and that have, of course, very important gender dimension. That is technological development. Of course, we are all witnessing technological development. It is presumed that in next few years, 14% of all employees in European Union will be dismissed because of technological change. Of course, many new jobs will be created, but when it comes to those dismissed workers, many of them will be female workers, because, of course, those jobs that will be actually eliminated from the labor market are usually those lower paid routine jobs that are usually performed by female workers, and unfortunately those dismissed female workers will not be able to find new job in that new sectors that will be created, the new knowledge elite sector, as is it called, because they do not have necessary skills for performing those new jobs that are going to be created. That they don't have new skills for those jobs. Why? Because of the breaks in a career, because of family duties. They do not have, because they used to work part-time, they used to work in the form of undeclared work, and they didn't have a chance to actually have acquired those skills and knowledges that are of importance for performance of those jobs that are going to be actually introduced because of technological change. And that is a quite challenging issue for contemporary labor law, how to actually cover that skills gap. That is some kind of gender skills gap. Yes. Yes. And then there is a climate change. Professor Dragica mentioned that. Climate change, well, also with important gender perspective. Why climate change, among much else, have harmful effects on businesses. Of course, it can also create opportunities for new jobs to be introduced in the labor markets. But the negative effects of climate change are harder on women because due to the poverty, women are more dependent on natural resources than men are. And also because of some social and cultural norms, women have less geographical mobility in the event of natural disasters, and consequently they have less chance to find a new job in the event of climate change. So this is also actually very important for female workers. And please do not forget that women do make up the majority of workers in the field of food production, which is actually the sector which is influenced a lot by climate change and negative effects of climate change. So, as some kind of conclusion, when it comes to this second issue that we examined, we can say that contemporary labor law is primarily aimed at women's empowerment in the world of work. Of course, that is justified because many female workers do have problems to find a job, to maintain the job, to advance in a professional career. But we have to have in mind that it is not possible to solve the problem which gender inequality in labor market is without participation of all stakeholders. Roles of social partners, see that of trade unions, employers associations, other workers' representatives is very important. The role of the state is very important, but of course strengthening of bipartite and tripartite social dialogue is not sufficient to actually achieve gender equality. As I said, contemporary labor law is aimed primarily at empowering female workers, since their position is very specific. But what do you think? Does contemporary labor law recognize the importance of role of men for implementation of the principle of gender equality? Is it possible to achieve gender equality without proper understanding of the importance of men in this activity or this goal? Do you think that contemporary labor law actually recognizes stereotypes that male workers are facing regarding gender issues? Just think about those labor law instruments for reconciling professional and family duties. They're mostly considered as a women's issue. Think about stereotypes that male workers are facing when they're, for example, enjoying the right to parental leave. Think about different cultural environments where those males that are actually on parental leave are facing, like mocking, like considering that colleague as someone who is not a real man, and so on. Yes, that is true. That's why it is important to also have that in mind. And then there are categories of male workers that do need special protection, and contemporary labor law does not provide it. Dear colleague, please, you wanted something to add.
Yes, I wanted to add that it's important to sensitize both partners, as I say, in this question, so both men and women, about their rights, about everything. Precisely in Serbia, a lot of people are not acquainted with our legal provisions for the parental leave. My personal case is that my husband took parental leave after me, but it was for our third kid, and I took 8 months and he took the rest. So it's 1 year and 4 months, yeah. And it's very interesting what we found out, that it's actually the number of men that took parental leave in Serbia is 138 or something like that. And I said, my husband, you should feel privileged. You're among the 130. I mean, I made a joke about that. But still, there was a great pressure. How should I say? Even he had this, how should I say, reconsiderations, psychological pressure, is this okay, how would I look, etc., etc. So it was either, how should I, open discussion, or I saw that this social pressure from time to time. So that's one question. Another, and even more important, why we only have had this in the case of the third kid, is that he, for the first 2 children, asked at his job place, but the employer told him that he's not allowed to take, that according to Serbian law, he can only take if the wife is dead, in a grave disease, or in prison.
Yes, which is
not true. It's not true. So people don't know. I mean, people don't have idea. That's the case in Serbia.
Yes. You're right. Thank you very much for this important intervention, and congratulations on third child and finding a time to attend this spring school. Literally great,
is now with the kids,
which is absolutely great. So you have to be proud on your husband as well as he has to.
be proud.
Yes, he has to be proud on you. Really, really great. Yes. And what about? Thank you very much, dear colleague. And what about other colleagues? What do you think about that role of men regarding achieving gender equality? Please, colleague Mina.
Maybe just before answering, we have one comment in the chat, so I can read it maybe.
Yes.
Yeah, our colleague Ivana Nikolic says, I would say it's still in the early phase, it's being considered, but it's still not enough in terms of addressing
Thank you very much.
this perspective. And
Thank you
also,
very much, Ivana, and thank you very much, Mina, for reading the comment, because although you cannot see the presentation, I cannot see the chat, so I'm not well equipped now. Okay, thank you. Please, Mina.
I have just one example from practice. It's not, of course, a representation of the general attitude, but just in terms of what we discussed. At Belgrade Open School, there are about 40 women working and 10 men. But it's not only the percentage of men and women, but also the fact that different procedures are completely created from the female perspective. So what was interesting, when we had some strategic planning with an external expert, the expert asked, do you consider your organization to be gender equal, inclusive? And everyone were unanimous in saying, yes, definitely. But it's precisely what you talked about, the lack of this perspective. Like, definitely, of course, dealing with gender equality requires dealing with feminist perspective, but also taking into account the specific challenges, stereotypes, and other facts that males are faced with in terms of labor market. So you just one example. I thought it would maybe be useful to mention it in this regard.
Yes, it was. Yes, it is. And what about others? Are there any other comments and impressions regarding the importance of role of men regarding achieving gender equality? Yes, we maybe along with colleague Ivana Nikolic, are there any other colleagues that are attending our class online and want to give a comment? Well, if not, maybe that is some kind of conclusion that we need both male and female workers included in this process of achieving gender equality, especially if we have in mind worsening of working conditions both for male and female workers in this contemporary time due to neoliberal influence and so on. And of course, when it comes strictly to gender issues, it is important to think about, of course, empowerment of women, since they're facing many problems to find a job, maintain the job, and advance in a career, but also to think about male workers and their specific needs and position regarding reconciling family and professional duties, but also other aspects of work. Now, as our dear Professor Dragica told me, we will have a short break and we will start at...
So catering came.
Very
So
important,
I'm
very important
but
information.
I think they're tired and maybe... So it was planned catering to be after completing the lecture, but maybe for you who are here now, you can help yourself and have together coffee and something small. And later on, for others who will come, other attendants who will come for the delivery of certificates, please leave something of that. Leave something of that.
Equal opportunities, equal opportunity for all those that want it.
So maybe we shall make the break of 20 minutes, because then you will have enough time for the third lecture and for the discussion.
Yes.
20 minutes. So if now it is 2:22, the beginning.
Okay.
The beginning.
Okay.
The beginning of the ending
Okay.
of our spring school courses and holding this fantastic last course. Okay, thank you. So see you
in 22 minutes.
20
minutes. 20 minutes.
2:22. It will be in 20 minutes. Thank you.
See you.